and observe the courts. The record will reflect that State's Counsel is present. And so let me ask, sir, are you Fernando Carrillo?
Yes, sir, I am.
Mr. Carrillo, an indictment has been returned into this court charging you with a second-degree felony offense of aggravated assault. Have you been served with a copy of the indictment in this case?
Yes, sir, I have.
Have you had that copy for at least 2 days?
Yes, sir.
Mr. Carrillo, you have the right to have someone read the indictment out loud to you, even though you've already received a copy. Do you wish to have someone read the indictment out loud to you?
No, Your Honor, I don't.
Do you understand that the indictment does charge an aggravated assault offense?
Yes, sir.
In the indictment you received a copy of, is your name spelled correctly?
Yes, sir.
And is Fernando Carrillo your true and correct name?
Yes, Your Honor.
Mr. Carrillo, as I am looking at the indictment, the indictment alleges a second-degree felony and then also alleges an enhancement paragraph. If a person is convicted of a second-degree felony, the range of penalties they face runs from not less than 2 years to not more than 20 years in the Texas Department of Criminal Justice. There is also the possibility that a fine could be imposed for a second-degree felony if a conviction occurs. The fine would be in some amount, could be in any amount, not greater than, not exceeding $10,000. Do you understand that's the possible range of penalties for a second-degree felony?
Yes, Your Honor, I've got some window popped up here. It says, let's cross this one off your list. Windows is continuously improving and updates are normal part. How do I get out of that?
I'm not sure, again, what that window says. Does it have an X in the upper right corner?
No, it says start now, pick a time and remind me tomorrow. The next update is ready for you. I guess it's an update is what it is.
It's an update to the computer.
Okay, maybe I'll push remind me tomorrow or something?
Yes, sir, that'd be great.
Okay.
All right, sir. Technology sometimes presents its own problems.
Yes, sir.
Mr. Carrillo, as I mentioned, your indictment also has what we call an enhancement paragraph. If all of the allegations in the indictment are established, if a conviction occurs on a second-degree felony, and then there is an enhancement paragraph that is proven to be true, then that's what enhancement means and where that term comes from. It means the punishment range would be enhanced or could be enhanced all the way up to a first-degree felony, which carries a range of penalties of not less than 5 years to not more than 99 years or life, and also carries the possibility that a fine could be imposed, and if imposed, in an amount not to exceed $10,000. Do you understand that's the punishment range for a second-degree felony that has a prior enhancement, a prior conviction alleged and proven to be true?
I didn't know there was an enhancement on this charge. Is that what that other paragraph is under that?
That's what that other paragraph is. Let me look at it with you. It alleges, and it's an allegation. That just means it's an allegation. that in 2016, on March 17, 2016, in this court, you were convicted of the offense of assault of a public servant. That's the allegation. If you are convicted of the underlying offense, and if this allegation proves to be true and is established by evidence that it is true, then that enhancement paragraph would increase the punishment range to that of a first-degree felony, as I've outlined it to you here in this video conference. Do you understand that now?
I'm still kind of lost on that. You're talking about, I've already been convicted of the assault on a public servant.
That's what the indictment alleges. And when that occurs, if it occurs, and if all of that is proven, then it increases the range of punishment that a person faces.
You're
That's
talking
all.
about the indictment that I've got this last time, right? About the aggravated assault?
Please ask your question again.
You're talking about the aggravated assault charge. If that gets proven to be correct, then my charge will be enhanced. Is that what you're trying to tell me?
I'm telling you that the indictment alleges that, and therefore that is possible. There still has to be proof of all of that. It's not automatic. But if that proof exists, then yes, sir, the enhancement range would be in play. All right, sir.
If I was to enter a plea of guilty, then that would automatically, yeah, because I was gonna try to see if, I know how the system works, and I've been in your courtroom several times, and I know you're a judge. You're a good judge, and I really don't want to fight the system. I don't want to fight y'all. I know there's so many things that went on that day that I'm just not. I'm very sorry.
Concerned about.
Yes, sir.
All right, let me make this suggestion. I'm not trying to get you to do anything at all, but I need to get through the arraignment,
Yes, sir.
and then I believe you would be benefited by consulting with an attorney who also knows the system, who would also have your interests at heart as their primary charge, who would then try to work with you and the district attorney's office,
Yes, sir.
then ultimately with the court and even a jury, if that were to be the case, that was needed. But the attorney could help you assess all of the matters to be considered.
Yes, sir. He's the one that would be talking to y'all, right?
I didn't hear that last part.
He's the one that would consult y'all, and then after that, he'd let me know what's going on, right?
That's right. He would coordinate between you and the district attorney's office and then the court, my office.
Yes, sir.
Let me ask you, sir, is your name spelled correctly in the indictment?
Yes, sir, it is.
And is Fernando Carrillo your true and correct name?
Yes, sir.
To the underlying charge of aggravated assault, for right now, not necessarily what you're going to do when your case comes to court, but for right now, what plea do you wish to enter? Guilty or not guilty?
Guilty, Your Honor.
Have you applied for a court-appointed attorney?
I have, Your Honor. I actually did that a few days, maybe about 2 days back. My family was gonna try to get me an attorney, but it's costing way too much money, and I think I'm just gonna go with one of the court-appointed attorneys. I talked to my mother yesterday, and I told her I didn't want them to help me. I was gonna go ahead and get one of your attorneys to help me.
All right. The person from my office who helps persons in your situation fill out the request for a court-appointed attorney indicates that he has not talked to you yet about that. There are forms, and you said you've already filled one out.
Yes, Your Honor.
I'm going to ask him to look at your request form and to make sure that it's all filled out. If not, to visit with you again and to make sure that it is properly notarized. And if you qualify and for a court-appointed attorney, uh, we will appoint an attorney to represent you. We will try to get that done today
Yes, Your Honor.
so that the process of the attorney visiting with you and beginning to coordinate between you and the DA and the court can get started. So you will not be left out there by yourself.
Yes, Your Honor.
We'll try to get that accomplished as quickly as possible. Um, but it will be later this morning at best before Mr. Hanshoe is able to visit with you. He will probably visit with you just as we are visiting right now. That is, with you sitting there in that room in front of that computer, and he will be at his computer, and he'll consult with you over the video conference. But that's all that our arraignment takes or includes this morning, except there is another document that the jail staff should give to you. They may have placed it there on the table in front of you,
No, Your Honor.
entitled, not there?
No, Your Honor.
All right, I will talk to them and ask them to get it to you. It's entitled, it will be entitled Acknowledgement of Arraignment. It's designed to say what we have already talked about, except for the part about the attorney. In the bottom left-hand portion of that document, there's a place for you to note your plea. Just circle it and then give it back to the jail staff. If you have any questions about that document, you can raise them with Mr. Hanshoe when he talks to you about your application for court-appointed attorney. Do you have any questions? We're through with your arraignment at this point in time. Do you have any other questions?
No, Your Honor. I'll just wait for my attorney and I'll get with him and see what we can get together.
All right, sir.
Thank you, sir. You have a good day.
Thank you, sir. You too. First one. How do we work? How do you want to work that? Let me read this. Okay. Maybe we can do it. Maybe we can get through these and get that done. Ms. Phipps, you might look up and see who represented him back in 2016.
That would be James Craig.
Okay, so he's not available. Oh, would you, Ms. Phipps, would you ask the sheriff's office, the jail staff, to have an acknowledgement of arraignment form there on the bench? I mean, they're on the table with the defendants?
Yes, sir, I already have.
Okay. I know. Scary sometimes. Are you Justin Wade Douglas?
Yes, sir.
Mr. Douglas, I'm calling cause number 10,788. The case is styled the state of Texas versus Justin Wade Douglas. This is an arraignment hearing, and it is being conducted by remote video technology using the Zoom protocol. It's also being live streamed on the court's YouTube channel. Mr. Douglas, an indictment has been returned into this court. Have you received a copy of the indictment in your case?
Yes, sir.
And have you had that for more than 2 days?
Yes, sir.
You have the right, Mr. Douglas, to have someone read that indictment to you, even though you've already received a copy. Do you wish to have someone read the indictment out loud to you?
No, sir.
I didn't hear that.
No, sir.
All right. Do you understand that the indictment charges you with a state jail felony offense of possession of a controlled substance?
Yes, sir.
In the indictment that you received, is your name spelled correctly?
Yes, sir.
And is Justin Wade Douglas your true and correct name?
Yes, sir.
Mr. Douglas, as I've mentioned, this charges a state jail felony. A state jail felony carries a range of penalties running from 180 days up to 2 years in state jail. It also carries the possibility that a fine could be imposed in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face under this charge?
Yes, sir.
Understanding the charge and now understanding the range of penalties as I've outlined them to you, to the charge of possession of a controlled substance, how do you wish to plead? Guilty or not guilty?
Guilty.
Do you have an attorney representing you?
No, sir.
Is it, oh, I'm sorry. I'm looking again at the file, and you have previously requested a court-appointed attorney. Do you know that?
Yes, sir.
Okay. And I have appointed an attorney by the name of Sam Darnell. It's pronounced Darnell, but it's spelled as if it would be pronounced Darnall. We have notified him by, I think we notified him by email and by mail. So he should have received a copy of that notice, and that requires him then to begin to give you notification that he represents you. They're handing to you a document entitled Acknowledgement of Arraignment. Is your name on that document?
Yes, sir.
Please look at that document, read it. It is supposed to say what we have already been talking about. If it does, then circle your plea and sign the document. If it doesn't say what we've talked about, then we need to talk about it further.
And then I just sign it?
Circle your plea on the bottom left-hand part. Guilty or not guilty, circle one of those. And then sign it. Do you have any questions about that document?
Sir.
Do you have any questions about this arraignment hearing?
No, sir.
Do you anticipate or plan to bond out on this charge?
Yes, sir.
When you bond out, you will report to the Community Supervision and Corrections Department for a bond supervision. Bond supervision will require you to pay a $50 per month supervision fee. And then in addition to that, you will pay $100 each month to reimburse the county for expenses incurred in your behalf.
Yes, sir.
You will report, after you bond out, you will report for bond supervision between the 15th and 20th days of every month until your case is disposed of. All right, sir. But you're about to be excused. Let me give you an opportunity again to ask any questions that you might have. Do you have any questions?
No, sir.
All right. Thank you, sir. You may be excused.
Thank you. Do I take this paper?
Oh, hold the paper up to the screen and a little bit higher so I can see the signature. I can't see the signature. Did you sign it?
Oh, defendant.
All right, sir. Is that your signature?
Yes, sir.
And do you have any questions about that document?
No, sir.
If you would hand that to the jail personnel as you leave the room, they will then cause it to be brought to the courthouse, and we'll be placing it in your file.
Yes, sir.
All right, thank you. You may be
Thank you.
excused.
Yes, sir.
What were you saying was scary?
He said, "You're efficient." And I said, "Yeah, that's scary."
Most times I don't need to be told to do stuff. Most times.
Most of the time, you need to be told not to do something.
You're right on that, Judge.
We are. I've got to learn to mute myself. That's what my wife says too. And I do not have two ex-wives.
Whose paper is that? Look at that.
The next one.
No.
Yeah, the next. Good morning. Are you Marvin Eugene Sheets?
Yes, sir.
Mr. Sheets, we're about to conduct an arraignment hearing. We will conduct the arraignment hearing after I call the cases. I call cause numbers 10,801 and 10,803. Each of these cases being styled the state of Texas versus Marvin Eugene Sheets III.
Your Honor,
Yes.
there's a third case as well,
Oh, thank you.
10,805.
Thank you. I didn't go far enough. I also call cause number 10,805, also styled the state of Texas versus Marvin Eugene Sheets. Are you Marvin Eugene Sheets?
Yes.
Mr. Sheets, this is an arraignment hearing on these three cases. We are conducting this hearing by remote video technology using the Zoom protocol for that. Our hearings are also live streamed on the court's YouTube channel so that the public can have access to the court, thus satisfying what some contend is a requirement in the Texas Constitution that the courts remain open. Mr. Sheets, have you received a copy of the indictment in each one of these cases?
Yes, sir.
And have you had your copy of the indictment in each case for at least 2 days?
Yes, sir.
Under that scenario, you have the right to have someone read the indictments out loud to you. Do you wish to have someone read these indictments out loud to you?
No, sir.
Do you understand that in cause number 10,801, that indictment charges unlawful possession of a firearm by a felon, a third-degree felony?
Yes, sir.
And in cause number 10,803, do you understand that that indictment alleges possession of a controlled substance, a state jail felony, but also alleges 2 enhancement paragraphs alleging 2 prior state jail felony convictions which, if all is proven true, could enhance that punishment range to a third-degree felony. Do you understand that?
Yes, sir.
And then in cause number 10,805, the indictment alleges burglary of a habitation, which is a second-degree felony as it is alleged. Do you understand that's the charge in that case?
Yes, sir.
In these indictments, is your name spelled correctly?
Yes, sir.
And is Marvin Eugene Sheets III your true and correct name?
Yes, sir.
Mr. Sheets, the range of penalties for a state jail felony, such as is alleged in the underlying offense in cause number 10,803, runs from 180 days up to 2 years in a state jail and carries the possibility that a fine could be imposed, and if imposed, in an amount not to exceed $10,000. Cause number 10,801, as well as under the enhancement paragraphs in 10,803, those allegations could result in the punishment range being for a third-degree felony, which is not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, also with the fine possibility existing in the amount of not to exceed $10,000. Then finally, in cause number 10,805, the indictment alleges a second-degree felony, and the range of penalties for a second-degree felony runs from not less than 2 years to not more than 20 years in the Texas Department of Criminal Justice Institutional Division, as well as carrying the possibility that a fine could be imposed, if so, in an amount not to exceed $10,000. Do you understand those are the possible ranges of penalties that exist
Yes, sir.
under the indictments in these 3 cases?
Yes, sir.
There's someone from the jail staff who is handing you some papers that I will talk to you about in just a moment. I need to first take your plea in these cases. Now that I have explained to you what the charge is in each case, as well as the range of penalty that exists in each case, let me ask you, to the charge of unlawful possession of a firearm by a felon, how do you wish to plead, guilty or not guilty?
Not guilty.
And to the charge of possession of a controlled substance in cause number 10,803, which is as alleged as the underlying offense is a state jail felony, what is your plea, guilty or not guilty?
Not guilty.
And in cause number 10,805, to the charge in that indictment of burglary of a habitation, how do you plead to that charge, guilty or not guilty?
Not
I'm
guilty.
sorry, not guilty?
Yes, sir.
Okay. Do you have an attorney representing you in these matters?
I filled out the forms for one, but I'd like to say I just got in here, so they haven't given me one yet.
All right, sir. I just got the forms also. And I find that you are entitled to a court-appointed attorney. And I will sign the order that appoints an attorney to represent you in just a few minutes. In the meantime, the jail staff brought some papers. They should have, I think they brought 3 papers in, each one entitled Acknowledgement of Arraignment, one for each of these 3 cases. Do you see those documents?
No, they only brought me one.
Does it have all 3 numbers at the top?
It's got two of the case numbers at the top.
Which 2 does it have?
The 10801 and 10803.
If you would, add 10805.
Judge,
Yes,
he's previously had Mr. Keith.
okay. Thank you.
Okay.
That document, Mr. Sheets, is designed to say what we have already been talking about. I would ask you to read it, make sure that it does say what we've talked about and not anything else, then at the bottom left-hand part of the document, if that's what it says, in the bottom left-hand part, circle your plea of not guilty. Since you enter a plea of not guilty for all three charges, you can use that one form and then sign your name. If it doesn't say what we've talked about, or you have any question about it at all, let me know before you sign it.
Okay. Okay, it's circled not guilty.
All right, sir. Have you signed it?
Yes.
All right, sir. Do you have any questions about that document?
No, sir.
All right, I have, we use a rotation system of attorneys, and I'm going to appoint an attorney to represent you. We also use a system that says if you have previously been represented by someone on our appointment system, that we will reappoint that attorney so that you don't have to spend a whole lot of time getting reacclimated with an attorney. Mr. Trey Keith has represented you before in this court.
Yes, sir.
And so we're going to appoint Mr. Keith to represent you in these cases. We will notify him of that today. That concludes your arraignment process today. Do you have any questions?
No, sir.
If you will hand that document that you signed and circled your plea, if you'll hand that to the jail staff, they will cause it to be brought to the courthouse, and we will place it, a copy of it, in each of your files. Thank you, sir. You may be excused.
Thank you.
Kayla, who did we appoint to represent Carrillo?
We didn't. Terry still has to review the.
Oh, yes. Okay. All right. Thanks. I just have one more defendant on my list. That's Raymond Hernandez. While it's just us and the defendant, well, here comes Mr. Hernandez. We'll wait. Are you Raymond Hernandez?
Yes, sir.
Mr. Hernandez, we are about to conduct an arraignment hearing in some cases that you have. Let me call them. I will ask you again your name in just a moment, or ask you if your name is Raymond Hernandez. And then we will make a couple of pronouncements and get started. I call cause numbers 10,806, 10,807, and 10,808. Each case being styled the state of Texas versus Raymond Hernandez. This is an arraignment hearing being conducted by remote video technology using the Zoom protocol. This hearing is also being live streamed on the court's YouTube channel to provide access to the public to the courts. The record will reflect the state's counsel is present with us by this video conference. Are you Raymond Hernandez?
Yes, sir.
Mr. Hernandez, 3 indictments have been returned, all 3 of them charging you with a different burglary of a building charge. Have you received these 3 indictments?
Yes, sir.
And have you had them for at least 2 days?
Yes, sir.
you have the right to have someone read these indictments out loud to you here in open court. Do you wish to have someone read the indictments out loud to you?
Yes, sir.
Mr. Smith, would you read the indictments to the defendant?
Yes, Your Honor. The first one is cause number 10,806, the state of Texas versus Raymond Hernandez. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January-June term AD 2020 of the 132nd Judicial District Court for said county, as extended under the authority of the Texas Supreme Court 17th Emergency Order regarding the COVID-19 state of disaster dated May 26, 2020, and Section 24.0125 of the Texas Government Code, upon their oaths present in and to the court that Raymond Hernandez, on or about the 13th day of January 2020, and before the presentment of this indictment in said county and state, did then and there intentionally or knowingly enter a building or a portion of a building without the effective consent of Maricela Medina Villa, the owner thereof, and attempted to commit or committed theft of property against the peace and dignity of the state, signed by the foreman of the grand jury.
Let's stop there for a second. Mr. Hernandez, in cause number 10,806, which is the indictment the district attorney just read, is your name spelled correctly?
Yes, sir.
And is Raymond Hernandez your true and correct name?
Yes, sir.
All right. Mr. Smith, would you read the next indictment?
Yes, sir. This one is cause number 10,807. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January-June term AD 2020 of the 132nd Judicial District Court for said county, as extended under the authority of the Texas Supreme Court 17th Emergency Order regarding the COVID-19 state of disaster, dated May 26, 2020, and Section 24.0125 of the Texas Government Code, upon their oaths present in and to the court that Raymond Hernandez, on or about the 13th day of January 2020, and before the presentment of this indictment in said county and state, did then and there intentionally or knowingly enter a building or a portion of a building without the effective consent of Cole Fullwood, the owner thereof, and attempted to commit or committed theft of property against the peace and dignity of the state, signed by the foreman of the grand jury.
Mr. Hernandez, is your name spelled correctly in that indictment, cause number 10,807?
Yes, sir.
And again, is Raymond Hernandez your true and correct name?
Yes, sir.
Then Mr. Smith, would you read the last indictment, 10,808?
Yes, sir. In the name and by authority of the state of Texas, the grand jurors for the county of Scurry, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January-June term AD 2020 of the 132nd Judicial District Court for said county, as extended under the authority of the Texas Supreme Court 17th Emergency Order regarding the COVID-19 state of disaster, dated May 26, 2020, and Section 24.0125 of the Texas Government Code, upon their oaths present in and to the court that Raymond Hernandez, on or about the 8th day of January 2020, and before the presentment of this indictment in said county and state, did then and there intentionally or knowingly enter a building or a portion of a building without the effective consent of Nayeli Cabrera, the owner thereof, and attempted to commit or committed theft of property against the peace and dignity of the state, signed by the foreman of the grand jury.
And Mr. Hernandez, again, in that indictment, is your name spelled correctly?
Yes, sir.
And is Raymond Hernandez your true and correct name?
Yes, sir.
each of these indictments, Mr. Hernandez alleged state jail felony offenses. The range of penalties for a state jail felony, and thus would be true in each of these cases, runs from 180 days up to 2 years in a state jail, and each carries the possibility that a fine could be imposed. If imposed, it would be in an amount not to exceed $10,000. Do you understand that's the possible range of penalties you face for each of these charges?
Yes, sir.
So let me take your plea in each of these cases. In cause number 10,806, charging burglary of a building, alleged to be without the consent of Maricela Medina Villa, how do you wish to plead? Guilty or not guilty? Pardon?
Not guilty.
All right, sir. And in cause number 10,807, also alleging burglary of a building alleged to be without the effective consent of Cole Fullwood, how do you plead? Guilty or not guilty?
Not guilty.
And to the charge of burglary of a building in cause number 10,808, alleged to have been without the effective consent of Nayeli Cabrera, how do you wish to plead to that charge? Guilty or not guilty?
Not guilty.
And do you have an attorney representing you in these matters?
I believe it's Keith.
Yes, sir. Trey Keith?
Yes, sir.
All right, sir. I haven't seen someone from the jail staff, and I didn't notice as you walked in. They should be handing you a document entitled Acknowledgement of Arraignment. Did they
Yes,
give you
sir.
a piece of paper when you came in?
Right here.
All right. Does it have all three numbers, cause numbers at the top?
Yes, sir.
That document is designed to say what you and I have already been discussing. Please
Yes, sir.
satisfy yourself that that's what it says. And if you're so satisfied, then circle your plea of not guilty, which you entered in all three cases.
Yes, sir.
And thus we will make a copy and put one in each of your cases and then sign that document. But if you have a question about it before you sign it, let me know and we'll discuss your question.
Yes, sir.
Did you get that signed?
Yes, sir.
Did you have any questions about it?
I only got one question. Since I got indicted with these three cases, Trey Keys is my attorney, court-appointed lawyer on my first indictment. Is he able to be present for my be able to be my court-appointed lawyer on these other charges?
Yes, sir.
Okay, then that's all I have.
All right, sir. Then that concludes, and we have signed an order that names him and appoints him as your attorney in all three of the cases now.
Okay.
And we have notified Mr. Keith of that, and he should be in touch with you soon.
Okay.
All right, sir. Thank you, sir. You may be excused.
Thank
Give
you,
those-
sir.
Give that paper to the jail staff.
Yes, sir. Thank you.
You're welcome. All right, that concludes our arraignments, except for Carrillo. Well, let me let the staff assist Mr. Hernandez in leaving the room. I know what I can. There he is. All right, we will get in touch with jail and get Mr. Carrillo back when Mr. Hanshu can visit with him about his application
Okay.
for appointed attorney. And we'll let you know. I was going to ask you something else, but frankly, I don't remember what it was.
If it was with regard to what you sent me yesterday, Judge Rucker's email to you, you asked me to look at that and see if I had any different thoughts than you had. I don't. I think we're still allowed to impanel a new grand jury under the current rules as long as they don't change. So.
Yeah. Okay, well, and we should hear something more from the Supreme Court this week. So the speculation is.
Yeah.
And I'll coordinate with you when I hear something.
Okay.
All right, thank you. We're in recess.
Judge,
Yes.
before you exit, they're bringing in Mr. Carrillo. If you want to leave Terry on.
You want to do that, Terry? Yeah, he said that's fine.
Okay.
Did y'all need to see Fernando Carrillo again?
Yes, ma'am. Hannah is aware.
Okay, all right, we'll just double check it.
Okay. I think everyone else but you, Judge, can exit. I mean, if Ben wants to exit, I think he can. Not trying to boot him out or anything.
I can stay on or exit, whatever y'all would prefer.
Judge, are we supposed to be hearing you?
Ben, can you hear me?
Yes, sir, I can.
The judge, what'd you say? I wasn't listening.
I can hear you, Terry.
Okay. What do you want me to tell him?
Can you hear me now?
Yeah. Yes, sir, I can hear you now.
Okay. I've done something that has hidden me and I can't unhide me, and it also muted me. I was trying to get out of the scene. Yeah,
And
no.
now it's doing that.
All right. Never mind. You're welcome to stay in. What I would suggest, Ben, is that you mute yourself and even hide, quote unquote, hide yourself. And then we will notify you when Terry and Carrillo are through, and then you can get back on without having to rejoin.
Okay, that's what I'll do.
Okay, thanks.
And then if you will mute yourself again, I can unmute myself. Well, he wasn't talking to me, so I guess we can't do that.
I can't hear.
Form than what he's looking at. I can't do this right.
So you can't see me.
Well, he needs to be able to see me. What did you do so I can
Ask him if he can see you. You said you could see me.
from down there? But he can't. He can't. Can you see me, Mr. Carrillo?
Yes, sir, I can.
Oh, okay. Let me get one of these forms and I'll look at it.
Yes, sir.
Just trying to be efficient like the coordinator.
But
Do things without being asked.
if they don't line up, then I can't talk to him about it. All right, do you have your affidavit of indigence
I
form
do.
there?
Yes, sir.
And you filled most of it out, you think?
Yes, sir.
Okay, I'll kind of go down it line by line and just make sure we got everything right.
Okay.
And you don't have to put exactly what I tell you. If you put something like what I tell you, that's okay.
Okay.
But you got your date of birth and your phone number
Yes, sir.
and address.
Yes, sir.
Did you get your social?
Yes, sir. I did.
And did you have a driver's license?
No, I don't.
Can you put, I don't have one?
I put none.
Okay,
That work?
yes, sir. And then it says you currently incarcerated, yes?
Yes, sir.
Married?
Yes, sir.
Do you have any children?
I do have children, but not with the person I'm married to.
All right, that's okay. Number of children, of your children that live with you?
With me, no, I don't have any that live with me.
So did you put 0?
I put none on there.
Okay, and then number of your children that live with someone else?
5.
And you listed their ages?
Yes, sir.
Okay. And then you probably check, yes, I live with my wife?
No, I put no. Well, does anyone children live with you? Well, the next line under that is, does anyone other than your children live with you? I put no.
Okay, that one would be yes. Well, do you live with your wife?
No.
Oh, so do you live by yourself?
Yes, sir.
Oh, okay. Sorry, I was confused.
I live by myself, but I live in my mother's house. The address that I put up there is the address that I live on.
Okay. And then were you working before you got arrested?
No, sir, I wasn't working. I'm a contract laborer, so I mean, I work for myself, but I haven't been working here in the United States for over 2 years now.
Okay. Then on employer, put self-employed.
Okay.
And you haven't worked, and you can skip the phone number.
Okay.
You haven't worked in about the last 2 years?
Yes, sir, correct. Maybe
Then
2.5
put-
years, close to 3 years already that I haven't worked here in the United States.
All right, then when it says, when did you last work, you can just put 2 to 3 years. And then just put 0 on how much and how often are you paid?
Okay.
And then on that where it says if you're self-employed, what is the nature of your work? You can kind of put whatever it is that you do.
So contract laborer work?
Yes.
Or this? Okay.
And then on name of previous employer, have you had a job where you worked for someone else?
It's been a little while, but I used to.
Do you remember who that was?
That was, I used to work out there at Hermony for all the farmers out there. It was Ron Gable, and there's a couple of them that I worked for.
You can, I would put some local farmers or something like that.
Okay.
And then beside that, like when did you last work for them? If that was however many years ago.
I think that was back in 2016.
All right,
The
good.
year, 2016?
Yes.
Okay.
All right. And do you know if your spouse is employed?
I don't talk to her anymore. I don't know.
So put check no.
No. Okay.
All right. And then in that box below where it says place of residence, where were you living before you got arrested?
I don't remember the address for the house I was living in.
What address did you put at the top?
I put my address, 1125 Graves Road, which I've always lived at that address.
Okay. Was that a place you were renting?
No, we own that house. My mother owns it.
Oh, yeah, that's what you said. So check neither and live in my mother's house.
Okay, I put that there.
All right. Do you own any real property?
No, sir.
You can put none. None on do you own any automobiles?
No, sir.
Any other assets?
No, sir.
Put none on those. Do you have a bank account?
No, sir.
You can put none
Yes, sir.
or no, whatever you want. And then turn it over. I usually start with the box to the right. Your take-home pay, you haven't worked in a couple of years,
Yes, sir.
correct? So put 0. And 0 for your spouse. Do you receive money, aid, or help from anybody or anything?
No, sir.
Then put 0 all the way down those. And then go to the left when you're done.
Okay, I guess I had put $500 here on child support, but I thought that was what I had to pay. I guess I gotta mark that out, but it's in pencil. Is there any way I can get a pencil and erase this, or I can probably erase it here in a minute? I'll just put 0 on that.
Or you can just, put a 0 and then put a line through the 500.
Okay. Okay.
All right. And then on the box to the left, do you pay any of those bills right now, or does your mom pay them?
No, she pays everything right now.
Everything, food, everything?
Yes.
Then on all of those, put 0.
On child support, I was supposed to be paying, but I haven't been paying on that either. Do I put a 0 on that too?
Yes.
Okay. Okay.
And then there's like 3 spaces, blank spaces at the bottom of that box.
Okay.
If you want to write, my mother provides for me right now, or something like that.
On the right side?
Inside those boxes, right where it says other expenses,
Okay.
right underneath that somewhere.
Okay. Okay.
All right. And then have you tried to hire an attorney?
No, sir.
Put circle have not,
Okay.
and then go ahead and sign it today, which is the 6th day of August, 2020. And then sign it.
Okay.
And they will send that form to me and I will notarize it. So I'm going to ask you, do you swear that everything you put in that form is true?
Yes, sir, I do.
And you did sign it?
Yes, I do.
All right. They will send that form to me. I will notarize it. I will get it to the judge. And we will let you know who your attorney is by letter.
Okay.
If you'll stay right there, I think maybe the judge will try to get the DA back on the line and we'll talk to you a little bit more, but I'll have to tell him we're ready.
Yes, sir.
All right, hold on.
Ben, are you ready?
Yes, ma'am. I'll get back on here.
Judge is coming.
All right, we're back on the record, and I went off with the coordinator telling me something and I didn't pay attention. I apologize. Is that what she said? Okay. Mr. Carrillo, let me get us back on the record. We're back on the record in cause number 10,567, the case style, the state of Texas versus Fernando Carrillo. The record will reflect the state's counsel is present. Mr. Carrillo is present. The court reporter is present by video conference and is present in the courtroom with me. Also present is someone from the probation office. I've received your request for court-appointed attorney, and I find that you are entitled to an attorney, to the appointment of an attorney. The next attorney on our rotation system is an attorney by the name of Jeannie Fuller. The last attorney that we appointed to represent you is no longer available for appointment. He has gone to work, or the last we heard from him, he'd gone to work for the district attorney's office in East Texas. And so he cannot represent somebody charged with an offense. Mrs. Fuller is one of our more experienced attorneys, one of our more capable attorneys. I appoint her to represent you. We will get you some information to that effect, and we will notify her of that as well today. Do you have any questions?
No, sir, no.
All right. Then that, Mr. Smith, you have anything?
No, sir.
Just one question, I'm sorry.
Yes, sir.
Will she be coming to see me, or is it gonna be video like this? You said it was gonna be video, right?
It depends. She will communicate with you in ways that the sheriff's office will allow. That can be by video conference, it can be by telephone. And then there are some times when the attorney will actually come to the jail and talk to you in the jail.
Okay, and one more question. This, just when I talk to you and the DA, that's the only time I'm gonna be live on YouTube, right? When I talk to my attorney or anything like that,
That's correct. When you talk to your attorney, you will not be on YouTube at all. Just you two, the two of you will be together on either a telephone or a video conference. No one else will be permitted to be a part of that conference. It'll just be you and your lawyer.
yes, sir, okay, I understand.
Any other questions?
No, sir, that'll be it.
All right, then thank you, sir. We'll be in recess. Good luck to you. We're in recess.
Thank you.
I'm gonna try something else. What I really need to do is click on stop video instead of hide self view, if that's what I wanted to do. I had forgotten about that. I had done that once before. Yeah, I got to do mute as well. Yeah. Okay. Live and learn.